there was a lot of dispute about various documents. See, the problem in both sides faced this problem of reconstructing the records of Pakistan is young as countries. So the maintenance of record, and there was so much going on. So people had to sort of piece together stuff. There was no witness left alive there. One of the heirs of the Nizam went into the box, but he also was speaking out of recollections, which the court said really doesn't carry the matter very far. They tried, for one set of documents which we produced, they tried challenging those documents. The court said, if you have to challenge it, you should challenge it by bringing expert evidence. Very late in the day, I think in June, someday in June, they applied for allowing them to tender expert evidence. Of course, we opposed it, saying you can't do it at this late stage. And the judge declined that permission. Beneficial interest, they own the money. And fourthly was certain technical legal arguments on whether there can be a trust or cannot be a trust, which I won't bore you with. In their illegality plea, Pakistan tried very hard to persuade the English court to go into Operation Polo, what has been Pakistan's international position, saying this was a quote-unquote invasion by India. The English court declined the invitation, saying as far as they are concerned, under the 1947 Act, the Nizam was the sovereign ruler and Hyderabad was a sovereign state. Post its accession, post-1950, the British government recognizes India and it recognizes Hyderabad as a part of India. In fact, it noted one of the officers of the British High Commission is in Hyderabad. So he said, I'm not going to get drawn into this issue. We also pointed out that this is irrelevant because the claim is now jointly being brought by the Nizam's heirs in India, so one of us has to get it. And what could be the illegality in the Nizam's heirs claiming money? So that got thrown out. Pakistan again argued that India had misstated its position, lied as it were. In 1954 it had misrepresented that it had given away everything to the Nizam. What happened was, because in 1954 India was advised that to strengthen the case against Pakistan, you must assign your interest, lest somebody say that this was public money, therefore invested in the succeeding state of Hyderabad. So to facilitate that, there was an assignment. When that didn't work, in 1965, the Nizam assigned this claim back to India. So they tried to say that India misled the court in 54, saying they had no interest. The English court said nothing of the sort. They did the right thing to prevent the case from going into what's called a legal black hole. All these assignments were made, and we said none of this is of any relevance. The more important are the findings on limitation. The English court said that Pakistan went in 1954, fought till 58, and got a stay against the action by the Nizam's heirs. Waited till 2013, brought the action, and is now saying, give me the money because their claim is barred by time. They said, allowing such a plea will be an abusive process. Somebody who blocks a proceeding and prevents the other side from claiming the money cannot then turn around and say, now it's too late, you can't claim it now. So that was rejected. Finally, the beneficial interest case is something which will interest all historians. Pakistan came forth and argued that this was a payment for the arms they were supplying in Nizam. They said, based on certain papers they gathered from the archives of the British intelligence and others, there was one dubious Mr. Cotton, who used to do night sorties and drop arms in India. And he says, we paid him, and we were paying him, and this was therefore payment for that. The English court said, yes, there is evidence to suggest you were paying for arms, there is evidence to suggest you were supplying arms, but this account was not for that. And therefore said that we will not allow you this defense. The historians will be interested in seeing Pakistan's open acceptance that they were supplying arms. And who could they have been supplying them to? The Razakars, obviously, in India. Then they tried, India and the heirs of the Nizam settled the case. Because there was an interstate fight India was claiming on an assignment. They were saying prior to the assignment there was a trust, etc. India's position was, we don't want to fight this. We settled with them. Some money would go to India, some money would go to them. The settlement is kept confidential. The court refused the request to make the settlement public. They said it's between two litigants, for them to decide. So broadly, from India's point of view, India got something, or the Nizam's heirs got something. The wrongful claim by Pakistan had to be fought. We fought that claim, we won it. That's what we were doing for.
Created Islamic State of Pakistan. So clearly it seems that they kept on shifting grounds as well, which the judge noted about Pakistan.
Yeah, at times I have come across somewhere a public statement where they said that they were protecting this money for a Muslim family which they knew would be unfairly treated by India. And when it came to giving the money back, they said no. So all sorts of things have been said. I don't know how true it is, but I was given to understand somewhere some high functionary had said we were holding it for the Nizam because he had more faith in us.
So now,
that faith was clearly betrayed.
Since Jadhav has been mentioned and you took that case from the beginning to where it ended, are you satisfied with the follow-up and the response from the Pakistani authorities?
I wouldn't like to comment on that because that's work in progress. Trust, what do you call it? Different ways in which. So Pakistan said we are a sovereign nation, so we received $1 million from another sovereign. The court cannot ask why we got this money. So they ran two dimensions of this. One is saying the theory of trust, which applies between two individuals or two private persons or entities, cannot apply to sovereigns. And the second, they said, is non-justiciable, which is also interesting. So the judge said, take your pick. Either all issues are justiciable, can be decided by court, or all issues are not justiciable. You cannot say your claim against the bank is justiciable. But India saying, sorry, you're not the owner of the money is not justiciable. So either we decide all issues or we don't. And since you have come to court and moved the court and said, pay me the money, you have to show that you are entitled to the money. And the judge said, I'm deciding all this on private law issues. There is no great moment of public law or public international law involved. It's a question of A gave money to B. B was holding the money. C says, now I have got the money. A and C settle and jointly say, anyway, give the money to us and we'll decide what we want to do with it. These are all private law matters, and the law of England applies.